Section 4. Confusion or merger of rights. Article 1275. The obligations extinguish from the time the character of the creditor and the debtor are merged in the same person. It means that the obligation will be cleared if it meets a certain situation. Example, Boy Aguila is in debt to Boy Negro in the amount of 5,000 pesos. Boy Aguila issued a promissory note in favor to Boy Negro. Boy Negro negotiates the promissory note. Later, it is endorsed in favor to Boy Aguila. The promissory note returned back to Boy Aguila. Boy Aguila being the maker of the promissory note and the debtor, and also the creditor, which extinguishes his obligation. Article 1276. Merger which takes place in the person of the principal debtor or creditor benefits the guarantor. Example, Newmar owes Richard 300,000 pesos guaranteed by Nicel. Richard assigned his right to Mariel, who assigned her right to Ernie. Ernie assigned his right to Newmar's. Newmar's obligation is extinguished, and Nicel is freed from her obligation. Nicel, the guarantor, was benefited. Article 1277. Confusion does not extinguish any joint obligation except as regards the share corresponding to the creditor and debtor to whom the two characters concur. Example, Rara and Debbie owed Frank 2 million pesos. Rara and Debbie guaranteed that Rara will pay the whole 2 million pesos to Frank. That extinguishes Debbie's obligation to Frank. However, Debbie is liable to pay Rara 1 million pesos. Article 1278. Compensation shall take place when two persons in their own right are creditor and debtor of each other. Example, John owes Chris 5,000 pesos and Chris owes John 5,000 pesos. Since they both owe each other the same amount, they do not need to pay each other, as their obligation is extinguished by compensation.
Article 1279. In order that compensation may be proper, it is necessary to, number 1, that each one of the obligors be bound principally, and that he be at the same time a principal creditor of the other. So here, the parties be mutual creditor and debtor of each other, and their relationship is a principal one, that is, they are principal debtor and creditor of each other. Number 2, that both debts consist in a sum of money, or if the things due are consumable, they be of the same kind, and also of the same quality if the latter has been stated. So, when a debt consists of money, there is not much a problem when it comes to compensation to the concurrent amount. It is a matter of mathematical computation, and if the things due are consumable, they be of the same kind and also of the same quality if the latter has been stated. So, ato magbaga tayong specific thing may nag-agreean the dua nga parties, no? Kwarta or gente or a thing. Number 3, that the two debts be due. So, the law does not require that the parties' obligations be incurred at the same time. What the law requires only is that the obligations be due and demandable at the same time. So, yung ibig sabihin ng number 3 dito. Number 4, that they be liquidated and demandable. So, a debt is considered liquidated when its amount is clearly fixed. It is unliquidated when the amount is not fixed because it is still subject to a dispute or to a certain condition. Number 5. That over neither of them there be any retention of controversy commenced by third persons and communicated in due time to the debtor. So this means it cannot be disposed without the proof of the court. Consequently, compensation cannot operate because a third party is already involved whose claim will be determined by the court. So that is 1279. So we will move on to Article 1280. Article 1280. Notwithstanding the provisions of the preceding article, the guarantor may set up compensation as regards what the creditor may owe to the principal debtor. So, this means that the extinguishment of the principal obligation due to compensation carries with it the accessory obligation. A guarantor's obligation is an accessory one. Therefore, the guarantor is given the right to set up compensation as regards what the creditor may owe to the principal debtor. So that is 1280. So we will move on to Article 1281, which is compensation may be total or partial. When two debts are of the same amount, there is a total compensation. Okay, for example, A owes B the amount of 1,000 and B owes A the amount of 1,000. So, if two debts are the same amount, there is a total compensation. On the other hand, for example, A owes B the amount of 1,000 pesos and B owes A the amount of 700. So, if the two debts are unequal, the one who's lacking shall be liable for the unsettled debt. And that is Article 1281. Compensation may be total or partial. When the two debts are of the same amount, there is a total compensation. So, we will move on to Article 1282. The parties may agree upon the compensation of debts which are not yet due. So, on the other hand, ito yung tinatawag nating voluntary compensation. So, for example, Ken brought grocery items worth 30,000 pesos from Aling Puring store under a line of credit with a maturity date of 3 months. Just after 2 months, both Vic and Aling Puring agreed to settle the obligation. So, oray nung pananadaw ng video, mapanagbabayadan. Kasi nag-agree na nga dua, gabayadan natin. Oray ang pala nga Diyos. So, that is voluntary agreement. Di part na nga dua, di part ni Vic, nag-voluntary. So, nga nagbayad. Kanya Aling Puring. And that is Article 1282.
Article 1283. If one of the parties to a suit over an obligation has a claim for damages against the other, the former may set it off by proving his right to said damages and the amount thereof. Sa Article 1283, kung ang isa sa mga partido sa isang obligasyon ay may karapatan para sa mga pinsala laban sa isa, ang nauna ay maaaring ipawalang bisa ito sa pamamagitan ng pagpapatunay ng kanyang karapatan sa nasabing mga pinsala at ang halaga ng gildidor. And compensation may also take place when so declared by a final judgment of a court in a suit. A party may set off his claim for damages against his obligation to the other party by proving his right to said damages and the amount thereof. For example, Rowena owes Robert 10,000 pesos. When Robert demanded payment, Rowena failed to pay. In anger, Robert damaged the property of Rowena to the extent of 9,000 pesos. Rowena can set off the obligation of Robert to pay him damages in the amount of 9,000 pesos against his debt of 10,000 pesos. Article 1284. When one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. Before rescissible or voidable debts are judicially rescinded or annulled, they are valid debts. The parties may opt not to rescind or annul them. Consequently, until they shall have been judicially declared void, they can be compensated against each other. If the prescriptive period of the rescission or annulment of the debts are already lapsed, there is automatic compensation, and the same will not disturb anyone. In other cases, if the debt is rescinded or annulled, the compensation is also automatically cancelled, and there shall be restitution of what each party had received before the rescission or annulment. For example, A owes B 10,000 pesos. Subsequently, A, through fraud, was able to make B sign a promissory note that B is indebted to A for the same amount. The debt of A is valid but that of B is voidable. Before the debt of B is nullified, both debts may be compensated against each other if all the requisites for legal compensation are present. Article 1285. The debtor has consented to the assignment of rights made by creditor in favor of a third person, cannot set up against the signee the compensation which would pertain to him against the assigner, unless the assigner was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. If the creditor communicated the cession to him but the debtor did not consent thereto, the latter may set up the compensation of debts previous to the cession but not of subsequent ones. If the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also later ones until he had knowledge of the assignment. Example, A owes B 3,000 peso due yesterday. B owes A 1,000 peso due also yesterday. Both debts are extinguished up the amount 1,000 peso. Hence, A still owes B 2,000 pesos today. Now, if B assigns his right to C, the latter can collect only 2,000 from A. However, if A gives his consent to the assignment before it was made or subsequently, A loses the right to set up the defense of compensation. So, A will be liable to C for 3,000 pesos, but he can still collect the 1,000 peso owed by B. In other words, the compensation shall be deemed not to have taken place. Article 1286. Compensation takes place by operation of law, even though the debts may be payable at different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. For example, A owes B $5,000 payable in California. B owes A $250,000 payable in Manila. If A claims compensation, he must pay for the expenses of exchange.
Article 1287. Compensation shall not be proper when one of the debts arises from a depositum or from the obligation of a depositary or of a bailee in accommodatum. Neither can compensation be set up against a creditor who has a claim for a support due gratuitous title without prejudice to the provision of paragraph 2 of Article 301. Article 1288. Neither shall there be a compensation if one of the debts consists in civil liability arising from a penal offense. Instances when legal compensation not allowed by law, where one of the debts arises from a depositum. A deposit is constituted from the moment a person receives a thing belonging to another with the obligation of a safely keeping it and returning the same. Article 1287 uses the word depositum instead of deposit, which is issued for an ordinary bank deposit. A bank deposit is not a depositum as defined above. It is really alone creates the relationship of a debtor and a creditor. As a general rule, a bank has a right of set off the deposits in its hands for the payment of any indebtedness owed on the part of a depositor. Similarly, a depositor has every right to set off his money deposit with a bank against the loans he had obtained from said bank. Example, A owes B 1 billion, in turn owes A the amount of 1 billion representing the value of a ring deposited by A with B, which B failed third turn. In this case, B, who is the depositary, cannot claim legal compensation even if A fails to pay his obligation. The remedy of B is to file an action against A for the recovery of the amount of 1 billion. The relation of the depositary to the depositor is fiduciary in characteristics since it is based on trust and confidence. B's claim for compensation against A would involve a breach of that confidence. But A can set up his deposit by way of compensation against B credit. This is an example of facultative compensation, also known as number 2 and 4 infra. The benefit granted by law is available only to A as depositor and can be waived by him. Where one of the debts arises from a commodatum. Commodatum is gratuitous contract whereby one of the parties delivers to another something not consumable so that the latter may use the same for a certain time and return it. Example, in the preceding example, if B borrowed the ring of B, cannot refuse to return the ring on the grant of a compensation because no compensation can take place when one of the debts arises from a commodatum. The purpose of the law is prevent breach of trust and confidence on the part of the borrower. A, however, can assert compensation of the value of the ring against the credit of B, where one of the debts arises from a claim from support due gratuitous title. Support comprises everything that is indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation, in keeping with the financial capacity of the family. Article 1289. If a person should not have against him severable debts which are susceptible of compensation, the rules on the application of payment shall apply to the order of the compensation. Rules on application of payments applicable to order of compensation. Compensation is similar to payment. If a debtor has various debts which are susceptible of compensation, he must inform the creditor which of them shall be the object of compensation. In case he fails to do so, then the compensation shall be applied to the most onerous obligation. Example, A is indebted to B in the amount of 1,000 without interest due today, without number 2, 1,000 with interest of 12% due to also today, and number 3, 1,000 with interest of 10% due yesterday. B owes A a 1,000 due today. For purposes of the application of a payment, A is a debtor. He must specify to B which of the 3 debts shall be compensated. If he fails to inform B, then the latter should apply the compensation to the second obligation of A, namely, the obligation bearing the 12% interest because it is the most onerous obligation. Article 1290. When all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law and extinguishes both debts to the concurrent amount, even though the creditors and the debtors are not aware of the compensation. Consent of parties not required in legal compensation. Number 1. Compensation occurs automatically by mere operation of law. From the moment all the requisites mentioned in Article 1279 concur, the legal compensation takes place automatically, even if the absence of agreement between the parties and even against their will, and extinguishes reciprocally both debts as soon as they exist simultaneously to the amount of their respective sums. It takes place if due from the day all the necessary requisites concur, without need of the conscious intent on the part of the parties and even without. Number 2. Full legal capacity of parties not required, as it takes place by mere operation of law, and without any act of the parties is not required that the parties have legal capacity to give or to receive as the case may be. One of the other hand, in order that there may be a valid payment, the parties must have the free disposal of the thing due and capacity to alienate it and to receive payment as the case may be. Compensation. A matter of defense, although compensation is produced by operation, it is usually unnecessary to set it up a defense in an action demanding performance. Once proved, its effects retroact or relate back to the everyday on which all the requisites mentioned by law court or are fulfilled. Example, in a case X bank intercepted funds being coursed through it for transmittal to another bank and eventually to be deposited to the account of an individual Y who happens to owe some amount of any to X. The Court of Appeals ordered X to return the intercepted amount to Y, who in turn was found by the court to be indebted to X. X claims legal compensation, held X petition is a clever ploy to this court to validate or legalize an improper act, could have easily disposed of this controversy in 10 minutes fast by means of an exchange of checks with Y from the same amount from X. Instead, this plainly unmeritorious case had to clog our dock and take the valuable time of its court.
Good day everyone. I am Queen Amery B. Bragado from BSBA 1H, and I will be going to report the Section 6 novation of the obligations and contracts from Article 1291 to Article 1295. So let's begin. Article 1291. Obligations may be modified by changing their object or principal conditions, substituting the person of the debtor, and subrogating the third person in the rights of the creditor. So first, what is novation? Novation is the total or partial extinction of an obligation through the creation of a new one, which substitutes it. It is the substitution or change of an obligation by another, which extinguishes or modifies the first, either by changing its object or principal conditions, or by substituting the person of the debtor, or lastly, it can be subrogating a third person in the rights of the creditor. So when we say novation, it is allowing a substitution from another person who is more capable in fulfilling one's obligation. For example, let's assume that Mr. Pepito is our debtor and our creditor is the Honda PH company. Mr. Pepito purchased a car in Honda PH company wherein it is payable for 3 years. So he pays monthly. But it came to a time that Mr. Pepito can no longer oblige his obligation due to fortuitous events. Therefore, novation will allow Mr. Pepito to be substituted by someone who is more liable than him. So a third person will arise. Another example of novation. When a person, as a seller, agrees with the buyer to pay the price to a third party as new creditor of its debt. In this case, the debtor will be freed by the initial creditor being bound to the new one as effect of novation. So, novation is used when a third party enters an agreement to replace a departing party in a contract. Usually, a new party would assume obligations to pay another party that the original party has intended to pay, thus releases the debt from one party to another. Now that we are aware what novation is, let's proceed to the dual function or the purpose of novation. Novation is a contract containing two stipulations of both parties. One is to extinguish or modify an existing obligation, and the other is to substitute a new one in its place. Unlike other modes of extinction of obligation, novation is a juridical act with a dual function, wherein it does not operate an absolute extinction in the sense that it ends with the extinguishment of an obligation, but only as a relative extinction, because it creates a new one in the mind and place of the old, which is the only modified. The novation is extinctive when an old obligation is terminated by the creation of a new obligation that takes the place of the former because of the total incompatibility between the two obligations. An extinctive novation would thus have the twin effects of first, extinguishing an existing obligation, and second, by creating a new one in its instead. But when the change is not extinctive but is merely modificatory, incidental to the main obligation, the new agreement won't have the effect of extinguishing the first but would merely supplement it or supplant some but not all of its provisions. In other words, the old obligations subsist to the extent it remains compatible with the amendatory agreement. Now that we know what novation is and the dual or purposes of novations, let me discuss also the kinds of novation. There are 4 kinds of novation. The first one is according to origin. It has 2 types, the legal and conventional. So legal takes place by operation of law, that the actions of both the debtor or the creditor must still be in accordance with the law itself. It would be voluntary, unilateral act, and can be lawful act. Next is the conventional. When we say conventional, it takes place by agreement of the parties. It is based on the stipulations of the debtor and or the creditor. It arises from the contracts itself, the agreement itself. The second one is according to how it is constituted, whereas it contains the express and implied. Express is declared when it is unequivocal terms. So when we say unequivocal, it is unmistakable or it is direct. While implied, it is when the old and the new obligations are essentially incompatible with each other. The third kind of novation is according to extent or effect. Number 1 is the total or extinctive. It arises when the old obligation is completely extinguished or it is being completely modified. The second one is the partial or modificatory. This happens when the old obligation is merely modified, or the change is merely incidental to the main obligations. And the fourth type of novation is according to the subject, where it contains the real or objective, personal or subjective, and mixed. First, let me discuss what real or objective means. When we say this, it happens when the object or the principal condition of obligation are changed. For example, Mr. A agreed to deliver a sack of rice to Mr. B. But later on, they made another agreement which instead of delivering a sack of rice to Mr. B, Mr. A would instead deliver a computer. So the object or the cause or the principal conditions was being changed. Instead delivering a sack of rice, it became a cell phone. So that's how real or objective happens. The second one is the personal or subjective. This happens when the person of the debtor is being substituted, and or when a third person is subrogated in the rights of the creditor. The main reason why the person of the debtor is being substituted is because of a fortuitous event or incapable of fulfilling his or her obligation itself. So that's why novation allows a substitution. And the third type of according to the subject is the mixed. This happens when the object or principal condition of the obligation and the debtor or the creditor or both parties of the agreement are being changed. It is a combination of real or objective and personal or subjective novations. Let's have this situational. S subscribed 100 shares of stock at par value in a company whose authorized capital stock was 250,000 pesos. At the time of the subscription, and without his knowledge and consent, the company increased the capital stock to 500 pesos. Or should I say 500,000 pesos. So the question is, can S be compelled to pay for said shares? So, can you think about it? Of course, no. Because the increase constitutes a novation by changing the principal conditions, wherein he is not bound by the contract, thus novated and is relieved of the obligation contracted by him in the original contract. Even if he made some partial payments, not having been informed of said increase at the time of having made them, so as is not compelled to pay for the said shares. So let's proceed to Article 1292. In order that an obligation may be extinguished by another which substitutes the same, it is imperative that it be so declared in unequivocal terms, or that the old and new obligations be on every point incompatible with each other. So in this article, it consists of different requisites of novation, where it has 4 essential requisites, namely, the first one is the existence of a previous valid obligation. The second one is the intention or agreement and capacity of the parties to extinguish or modify the obligation. The third one is the extinguishment or the modification of the obligation. And the fourth one, or the last one, is the creation or birth of a new valid obligation, where there can be no novation unless 2 distinct and excessive binding contracts like place, time, or between the same parties with the second designed to replace the preceding convention. So, what is novation of judgment? So when we say novation of judgment, it is a final judgment of a court that had been executed but not yet fully satisfied. It may be novated by compromise. In such case, the judgment cannot subsequently be executed because the agreement supersedes the judgment. Therefore, the novation of a contract or judgment may be subject to a suspensive condition. Novation is not presumed. If there's a novation, it will always be expressed. No form of words or writing is necessary to give effect to a novation. It must be clearly and unmistakably established by express agreement or also by the acts of the parties, as novation is never presumed. So let's have an example regarding to the signatures of 2 debtors to novation were not obtained by creditor and third debtor. For example, by agreement of A and D, the separate debts of the brothers A, B, and C were consolidated in a new promissory note executed and signed by A and D. Therefore, A binding himself to obtain the signatures of B and C to the roll, but this was never done. In an action instituted by D against A, B and C alleged as a defense that as neither A nor D exercised proper diligence in securing their signature to the new note. There was consent to permit the obligation to stand as a debt of A alone. Let's go to Article 1293. Novation, which consists in substituting a new debtor in the place of the original one, may be made even without the knowledge or against the will of the latter, but not without the consent of the creditor. Personal novation may be in the form of substitution and subrogation. Substitution when the person of the debtor is being substituted. And subrogation is when a third person is subrogated in the rights of the creditor. There is also two kinds of substitution: the expromission and the delegation. Expromission or that which takes place when a third person of his own initiative and without the knowledge or against the will of the original debtor assumes the latter's obligation with the consent of the creditor, while delegation takes place when the creditor accepts a third person to take the place of the debtor at the instance of the latter. This happens also when the creditor may withhold an approval. In delegation, all the parties, either the old debtor and the new debtor and the creditor, must agree. It is very important to have a consent and agreement in this kind of substitution, because in expressionisms, payment by the new debtor gives him the right to beneficial reimbursement under the second paragraph of Article 1236. Whereas if the payment was made with the consent of the original debtor or on his own initiative or delegation, the new debtor is being entitled. For example, debtor tells creditor that X will pay debtor's debt. C agrees. It does not necessarily mean that there is delegation here. But if D tells B that X will pay his debt and he asks C to release him from his obligation, to which C agrees, therefore the result will become delegation. More so, substitute must be placed in the same position of original debtor. This means that it is not enough to extend the juridical relation to that other person, but it is necessary to place the latter in the same position occupied by the original debtor who is released from the obligations. Since it is necessary that the third person should become a debtor in the same position as the debtor whom he substitutes, this change and the resulting novation may be with respect to the whole debt, thus releasing as a general rule, which concludes that the debtor from his obligation, or he may continue with the character of such debtor and also allow the third person to participate in this obligation. Now that I already discussed the Article 1291 till 1293, let's now proceed to Article 1294. If the substitution is without the knowledge or against the will of the debtor, the new debtor's insolvency or non-fulfillment of the obligation shall not give rise to any liability on the part of the original debtor. When the substitution is without the knowledge of the original debtor, this means that the new debtor's insolvency or non-fulfillment of the obligations shall not give rise to any liability on the part of the original debtor. Article 1294 wants to implies that if there is insolvency on the part of the new debtor, the same cannot be enforced against the old debtor because the latter did not make the initiative in making a change which might have been made even without his knowledge. For example, why the creditor substitute X? X is the old debtor. With A is the new debtor without the knowledge of the former. Later, the insolvency of A became the liability of X, wherein that X should be absolved from liability because he did not initiate the said substitution. So, is it clear what Article 1294 implies? So if yes, let's proceed to Article 1295. Article 1295. The insolvency of the owner debtor who has been proposed by the original debtor and accepted by the creditor shall not revive the action of the latter against the original obligor, except when said insolvency was already existing and of public knowledge or known to the debtor when he delegated his debt. This Article 1295. The insolvency was already existing and known to the debtor, although it was not of public knowledge. But at the time of the delegation, the exceptions are intended to prevent fraud on the part of the old debtor. For example, DOC of 1,000 pesos. D proposed to C that X would substitute him as debtor. C agreed to that proposal. If at the time of the delegation, X was already insolvent but his insolvency was neither of public knowledge nor known to D, then D is not liable. Neither is D liable of the insolvency of X took place after he delegated his debt. It is believed that D is also not liable if C had knowledge that X was insolvent at the time the debt was delegated to him.
Article 1296. When the principal obligation is extinguished in consequence of an ovation, accessory obligations may subsist only insofar as they may benefit third persons who did not give their consent. The above article follows the general rule that the extinguishment of the principal obligation carries with it that of the accessory obligations. It provides, however, an exception in the case of an accessory obligation created in favor of a third person, which remains in force unless said third person gives his consent to the novation. This is so because A person should not be prejudiced by the act of another without his consent. For example, Chris owes 4 2,000 pesos with interest at 14%. 4 owes Christina 280 pesos. It was agreed among the parties that Chris would pay the interest of 280 to Christina. In this case, besides the principal obligation of Tris, there is a stipulation in favor of Christina, a third person. Later on, Tris and Four executed another contract whereby they agreed that Tris would deliver to Four a radio set in payment of the loan. In spite of the novation, the accessory obligation to pay the interest of 280 pesos to Christina still subsists unless Christina gives her consent to the novation. Article 1297. If the new obligation is void, the original one shall subsist, unless the parties intended that the former relation should be extinguished in any event. Article 1297 stresses one of the essential requirements of a novation, to wit, the new obligation must be valid. The general rule is that there is no novation if the new obligation is void, and therefore the original one shall subsist, for the reason that the second obligation being inexistent, it cannot extinguish or modify the first. If the new obligation is only voidable, novation can take place, but the moment it is annulled, the novation must be considered as not having taken place, and the original one can be enforced, unless the intention of the parties is otherwise. For example, Corpus is indebted to Abera in the amount of 2 million pesos. Since Corpus cannot pay his debt, Corpus and Abera entered into a new contract whereby Corpus will kidnap and kill the enemy of Abera, and the latter will consider Corpus' debt extinguished. In this case, the original obligation of Corpus and Abera shall subsist because the new obligation of Corpus to Abera is void, it being against the law. Article 1298. The novation is void if the original obligation was void, except when annulment may be claimed only by the debtor, or when ratification validates acts which are voidable. This article has its basis also on the requisites of a valid novation. A void obligation cannot be novated because there is nothing to novate. However, if the original obligation is only voidable, or if the voidable obligation is validated by ratification. Take note, a voidable obligation is valid until it is annulled in court. For example, Reyna obliged himself to deliver a car to Andrew. Later on, it was agreed between the two that Reyna will give Andrew cash worth 50,000 pesos instead of delivering a specific car. The original obligation is void because it has not yet been annulled by that the second contract is valid. Article 1299. If the original obligation was subject to a suspensive or resolutory condition, the new obligation shall be under the same condition unless it is otherwise stipulated. If the first obligation is subject to a suspensive or resolutory condition, the second obligation is deemed subject to the same condition unless the contrary is stipulated by the parties in their contract. The reason for the rule contained in Article 1299 is that the efficacy of the new obligation depends upon whether the condition which affects the old obligation is complied with or not. If the condition is suspensive and it is not complied with, no obligation arises. And if it is resolutory and it is complied with, the old obligation is extinguished. In either case, one requisite of novation, a previous valid obligation, would be wanting. For example, Gwen and Peter agreed that if Peter will graduate in college, Gwen will give Peter an iPhone 11. After that, Peter graduated in college, and later on the two of them agreed that instead of giving iPhone 11 to Peter, Gwen will give Peter an iPhone 10. The obligation is extinguished because the first obligation is to give an iPhone 11 to Peter, and the second obligation is in the same condition, which is giving iPhone 10 to Peter. tila ang nagdumaanda, tinaytad laang kat iPhone 10 nga iPhone 11. Article 1300. Subrogation of a third person in the rights of the creditor is either legal or conventional. The former is not presumed, except in cases as expressly mentioned in this code. The latter must be clearly established in order that it may take effect. Subrogation is the substitution of a third person, subrogee, in the place of a creditor, subrogor, with reference to a lawful claim of right, giving the former all the rights of the latter, including the right to employ all remedies to enforce payment. There are two kinds of subrogation. One is the conventional subrogation, and the second one is legal subrogation. Conventional subrogation must be clearly established in order that it may take place. Legal subrogation is not presumed except in the cases expressly provided by law. An example of a conventional subrogation is, nung nagbulog ni Nana ti 20,000 pesos kay ni Balmond with her guarantor, Gushon, it was agreed in the contract na in case madi makabayad ni Nana, di bulod na 20,000 kay ni Balmond may go against Gushon for the unsettled debt. An example also of legal subrogation is that Nala owes Simba 10,000 pesos. If Nala fails to pay, Simba may pursue the property of Nala to satisfy his claims. Nukurang jay property ni Nala to cover the debt, Simba can file an action subrogatoria to Nala. Action subrogatoria is an action where the first person whose claims had not been fully satisfied, he may go after the second person nga nakautang kay Nala. In this case, Nala owes Simba 10,000 pesos. If Nala fails to pay the 10,000 pesos kay Simba, Simba may pursue the property of Nala to satisfy his claims. No kurang jay property ni Nala to cover the debt na inutang na kay ni Simba, mabaling nag-file ni Simba ti action subrogatoria kay ni Nala. Dati kat no deji property ni Nala ket agkurang nga pangbayad kin dejay utang ni Nala kini Simba.
Article 1301. Conventional subrogations of the third persons requires the consent of the original parties of the third person. Generally, the debtor possesses the right to protect against the new creditor of any defense, which he, the debtor, could have set up against the old creditor. For example, here, Ray borrows 20,000 to Liz with the guarantors Yunjin. They agreed that Ray cannot pay the 20,000. Liz may go against Yunjin to pay the debt of Ray. And Ray fails to pay the 20,000 to Liz, so Liz may go against Yunjin's pay it. Article 1302. It presumes that there is a legal subrogations. Number 1. When a creditor pays another creditor who is preferred even without the debtor's knowledge. For example, Daniel owes Ninji 30,000 secured by the first mortgage of the land of Daniel. Daniel also owes Herin 40,000. This 40,000 debt is unsecured. Under the law, Minji, who is preferred creditor, has preference to payment with the respect of the land as against Herin, who is merely an ordinary creditor. If Herin pays the debt of Daniel to Minji, Herin will be subrogated in Minji's right, so that he can have the mortgage foreclosed in case Daniel fails to pay the 30,000 debt. Second one, when the third person not interested in obligation pays in the express or the tacit approval of the debtor. For example here, Sakura owes Yunjin 5,000 pesos, and Kazuha pays Yunjin with the express or implied consent of Sakura. In this case, Kazuha will be subrogated in the rights of Yunjin. Third one, when even without the knowledge of debtor, a person interested in the fulfillment of the obligations pay, without prejudice to the effects or confusions as to the latter shares. For example, here is Nicholas and Taki are joint debtors of Joe for the amount of 20,000 pesos without the knowledge of Nicholas. Taki pays the debt of 20,000 pesos. In this case, Taki becomes the creditor of Nicholas for 10,000 pesos. The latter shares of the debt but not for the remaining 10,000 pesos. The portion of the debt which corresponds to Taki, which is extinguished by confusions or merger of rights. Article 1303. Subrogations transfer to the person subrogated by the credit of all the rights thereto appertaining either against the debtor or against the third person. The guarantors or possessors of mortgage subject to stipulations into conventional subrogations. Here, in this article, the effects of subrogations is to transfer to the new creditor the credit and all the rights of the old creditor. For example, J owes Jakes 500,000 and Taeyon is the guarantor. Felix is the stranger and Kai paid Jake 500,000 pesos with the consent of Jay and Jake. Kai is now subrogated in the place of Jake. If Jay cannot pay the 500,000 pesos, Kai can proceed against the guarantors of Taeyon. And lastly, Article 1304. A creditor to whom partial payment has been made may exercise the remainder and he shall be preferred to the person who has been subrogated. In this place, on the virtue the partial of payment of the same credit, the third person who pays the partial payment of the person who is in debt will be the same person who will pay the unsettled amount of money. In case the debtor fails to pay the balance or remainders, the creditor may go against the third person who made the partial payment. For example here, Yuma owes Fuma 1 million pesos with the consent of both. EJ pays Fuma 500,000 pesos. Now, Fuma and EJ are the creditors of Yuma to the amount of 500,000 pesos. Suppose Yuma has only 500,000 pesos. Should be preferred? Yes. Okay. Fuma is the original should be preferred inasmuch as he granted by the law preferential right to recover the remainders over the person subrogated in his place by virtue of the partial payment of the same credit.